Hello, my name is Niko Soininen. I'm Professor of Environmental Law at University of Eastern Finland School of Law and Center for Climate Change, Energy and Environmental Law. Today I'm going to be speaking to you about the role of law in governing the complexity of river basins. This topic is one of the core topics of a newly established research group, Law in Water and Environmental Governance, together with Professor Antti Belinski from UEF Law School. The contents of the presentation are as follows. I will start by giving a short introduction to the complexities of global environmental challenges that we face today. After that, I will focus on water, mainly EU Water Framework Directive goals, seeking to transition to a more sustainable use of waters and establish river basins as complex systems that the Water Framework Directive seeks to regulate. In the third part, I'll ask whether our current governance structures at the EU and Finnish levels are fit for tackling the river basin complexity. And then in the fourth and fifth part, I will focus on discussing what are some of the legal forces and structures at play at the river basin and how we could move forward in tackling some of the most pressing environmental challenges of our time, in this context, water quality. Let us begin with the intro. So we currently face a number of pressing global problems. The Stockholm Resilience Center has described these as pushing the global planetary boundaries. Obviously, the problems are climate change, loss of biodiversity, overuse of natural resources, including water, and pollution of the environment in many different forms. Now, we have entered this era in which the human population is pushing these boundaries because of a phenomenon called the Great Acceleration. The Great Acceleration that you can see on the bottom right corner is basically an increase in human population globally, the increase of gross domestic product, the decrease of biodiversity and the increase of use of natural resources from the 1950s onward. These changes in human systems and economic systems are invoking global environmental change, climate change, biodiversity loss, overuse of natural resources and pollution, and they are incurring also complexities and uncertainties of how the global biosphere will endure these pressures. Now, what are the solutions for these big problems? If we look at the literature from political science, economics and law from the last few decades, we can clearly see that there are no silver bullets to these problems. There's no silver bullet to transitioning to societal sustainability because many of these problems are so ingrained in our way of life. And in this presentation, I'm trying to look at, from a legal perspective, what this no silver bullets argument means and what are some of the ways forward in terms of research, how to move forward in tackling these global environmental problems. Now, if we look at or focus on water more specifically, we see that the EU has set an ambitious target in the Water Framework Directive, which has been in force from 2000. And in Article 4, the directive stipulates that EU member states are required to reach good ecological status of waters, originally by 2015 and now by 2027. And furthermore, no further deterioration of water quality is allowed. So in what kind of context is this goal to be implemented? If we look at river basins, they typically contain a number of different components. Looking at the ecological components, we see that in the river basin you have the geological structure of the earth. At the hydrological cycle, you get water evaporation, rain and runoff, basically the circulation of water in the river basin, which is heavily affected in turn by the climate system. Now, water running off in turn brings nutrients and other substances into waters in which many aquatic species live. So already from this very shallow and brief introduction, we can see that the ecological system in which these Water Framework Directive goals are to be implemented is highly complex. Adding to that complexity is the social system, the number of human uses, economic uses of the environment, of the river basin. So basically, looking at many of the Finnish river basins, we see a number of activities. Damming of rivers for hydropower generation, recreational fishing and other activities, ditching of forests and cutting forests for economic purposes, agricultural use of land, animal husbandry there, spreading of manure, and then several industrial activities, mining sites, pulp mills, and so on. All of these activities have some impact on water quality and quantity. And how these impacts accumulate is a complex matter in and by itself. Now, furthermore, the technological system operating in the river basin is complex. You can see the dam structures for generation of hydropower, you can see the ditching of forests, you can see water retention areas, water purification sites, and so on. In addition, a number of cables and pipelines that move fresh water and wastewater in the basin. So a number of social, ecological and technological complexities in the river basin. Now, furthermore, the governance system that seeks to manage these different human pressures on water quality and also water quantity is complex. And governance altogether or in combination means all those processes of rule in which we come to decide as a society how to deal with water in the river basin. Now, looking at the public side of governance, we can see that governance is divided between multiple levels: international, EU, national, and subnational, as for instance, municipal governance actors and instruments. Also, there is sectoral divide on all of these levels of governance, typically between different actors governing generation of electricity, production of energy in general, use of natural resources such as fisheries and forests, and protection of the environment. So the governance system is complex as well. Now, this complexity actually explains quite a lot of the no silver bullet argument I presented on the first slide. Complexity is the reason why there are no simple, clear-cut solutions to water quality and quantity questions, but also not to climate change, biodiversity loss, and overuse of natural resources in general. Now, asking the question or looking at whether our governance structures are fit for the task, whether our current governance structures are fit for implementing the objective of the Water Framework Directive, the good status of waters, we can clearly see, judging based on the impact, that they're not. On the figure on the left side, everything that is not dark or light green is below the current status requirements. So looking at the coastal waters, half of the EU's coastal waters are below good status as required. 70% of transitional waters are below good status, 50% of lakes, and some 60% of rivers. The same story actually continues when looking at Finland on the right side. Everything there on the map that you see that is not blue or green is below the requirements of the directive, and there you can easily see where industrial and economic activities in Finland are located, mostly in the west, southwest and southern parts of Finland. So clearly, if we look at water status, water quality, the current institutions, the current governance structures are not fit for implementing and achieving the goals of the directive, despite much progress that has been made in the last 20 years. Now, an interesting question for a legal scholar is to ask, what is law as an institution? What are legal structures doing in the river basin? How are they affecting the governance of this complexity? How are they affecting in trying to aspire towards the good status requirement of the Water Framework Directive? And there we can see three basic forces pushing and pulling transition towards good status. So law in general functions first of all as a brake pedal. It slows down transition to good status. But it also functions or can function as an accelerator speeding up a transition. And thirdly and finally, it can function as a steering wheel managing the direction of the transition in the river basin. Looking at the dynamics a bit more closely, when the law functions as a brake pedal, we can see that law is actually one of the reasons or cementing factors in the background of our fragmented governmental structure. So basically division of labor between branches of government and also between the governance of natural resources, energy and protection of the environment, which makes harder to actually manage and govern a river basin as a whole. Second of all, law establishes a number of procedural rules like due process requirements, access to court and so on, which make it burdensome and time-consuming to, for instance, review existing permits of hydropower for restoring some of the rivers to their historical status. Thirdly, law establishes a number of substantive rules, like the constitutional right to property, that hinders and slows down a transition to sustainability, in this case, the good water status requirement. But not only does the law function as a brake pedal, it also functions as an accelerator. Law can help and helps in establishing institutions with capacity to integrate knowledge between different sectors and branches of government. One example being biodiversity and climate panels at the international level, but also at the Finnish level. Something similar could be imagined in water context as well. Procedurally, law can also, for instance, set lighter demands for restoring a water body, such as a lake, than considering a project that seeks to deteriorate the quality of the environment. The law can also help establish procedural rules for re-evaluating some of the existing activities in the river basin, such as hydropower dams. And furthermore, law establishes substantive rules, constitutional right to environment, and requires certain mitigation measures, best available technology, for instance purifying wastewaters in the river basin, which function as an accelerator for, and speed up the transition. Finally, we have goals, environmental policy goals established in the law that seeks to steer the direction of the sustainability transition. And the good ecological status requirement in the Water Framework Directive is one such goal or one such steering wheel. So, summarizing this slide, we can see that law has three main functions in the river basin. It slows down transition, it speeds it up, and it seeks to manage the direction of the transition. So brake pedal, accelerator, and a steering wheel. Now, coming toward the end of my presentation, how do we move this forward? How do we conceptualize, study, and imagine such legal instruments and such legal structures that would support a transition to sustainability and achieving the good ecological status requirement of the Water Framework Directive? Here, it is useful and I think helpful to think about law not as an instrument, not purely as an actor on a stage, but also as structure, the frame within which the actors are operating and playing. And for a sustainability transition, it may be more important to focus on these legal structures at play, these legal forces, accelerator, brake, and steering wheel, instead of individual legal instruments seeking to push transition to a certain direction individually. And this point, the very same point, has been made in different contexts by the International Panel on Climate Change and also the International Panel on Biodiversity. They've made the argument a number of times in the past few years that there's a need to change the legal structures in tackling environmental challenges. So basically, instead of changing the actors of the play, we're looking at the framework or we're looking at the stage on which actors are playing. But it isn't quite as simple as this. Our legal institutions, the procedures and substantive rules are the result of hundreds, if not thousands of years of legal development. So changing those structures in a short period of time, let's say 10 to 40 years, within which many of these environmental goals regarding climate change, biodiversity loss, overuse of natural resources and environmental pollution are to be realized, may not be realistic. At least it may not be realistic to tackle all of the structures at the same time. So much of the literature and research on environmental law has started emphasizing that we are operating in a certain legal reality within certain legal structures. We can't do away of the brakes, accelerators, and the steering wheels. They are there. We need to operationalize sustainability within those structures. And here it is absolutely key to recognize that law as a system, law as a structure, is a complex institution. It's a complex human operation. And it cannot be changed on a whim, basically because no one actor on any of the levels, international, EU, national, or below, has all the power to make this change on institutional, procedural, and substantive factors that would need to be considered in order to fully drive home a transition towards good ecological status of waters. And this finally brings about the point that including legal research and lawyers, legal scholars in interdisciplinary research seeking to figure out how best to achieve the goals of the Water Framework Directive and the sustainability goals is absolutely crucial. Thank you.